How's it going, everybody? As we've been talking a lot about the Google monopoly, digital rights, and how we're supposed to navigate this digital world, there have been a lot of other stories that have sort of fallen off the radar in this discussion. One of them being there's a story about this cop who's being forced to turn over his encryption keys or unlock a hard drive. He claims he can't remember it. It's a really fascinating story, and it's also pretty scary, so I figured I would meet with someone who probably knows a hell of a lot more. Well, I can say absolutely knows a hell of a lot more than I do. So I'm here with Fred. Would you like to introduce yourself?
Sure. I'm Fred Jennings. I'm an attorney at Tor Eklund PLLC, where we work on cybercrime defense cases, digital privacy, and digital rights. I've handled cases involving encrypted devices and involving a variety of charges that go to the heart of digital privacy.
So the reason I think this conversation is really important, just for everybody right away to get a sense of how serious this is, we're talking about potential indefinite detention. It's kind of what we're looking at. So would you be able to explain the story that I'm talking about? Would you be able to give us a quick run through?
Sure. Let me start with my mandatory disclaimer. This is not legal advice. I am speaking only on behalf of myself, not my firm or my clients. But yes, the case we're talking about is a case where a police officer is accused of having downloaded some amount of child pornography, and they have, I believe, seated a grand jury and ordered him to turn over the encryption key to the drives that this information is allegedly on. Now, he claimed he didn't remember it, didn't remember the password, had tried several times to enter a password and it failed. And as a result of that, the court entered an order ordering him to recall the password and to unlock those devices. Now, I think it sort of goes without saying that there are Fifth Amendment issues there with forcing someone to turn over a password, but I think it's also remarkable that a court is ordering recollection of memory that someone is claiming, whether you believe it or not, is claiming not to remember.
So, as I understand, this guy's been in jail now for a few years on contempt of court charges.
Correct. I think it's about 2 years now, and that's troubling for a number of reasons. For criminal contempt in general, it is one of those very rare areas of U.S. law where there is potential for relatively indefinite detention. Now, the procedural difference is that there's a few different types of contempt, but the sort of general standard is that once contempt becomes futile or it's clear that detention is not going to eventually result in compliance, the sort of safety valve to prevent this being actual indefinite detention is supposed to be that once it becomes clear that it's futile or not going to produce compliance, the procedural rules generally require either release or the change over to a definite term of detention.
So in this instance, it's been almost 2 years.
Right.
It's contempt of court because I think now they're saying that they don't need his passwords, they want him to unlock the drive, which he claims he can't do.
Correct.
So why is he still being locked up?
That's a great question, and it depends a lot who you ask. Part of this gets into a relatively specialized area around contempt law, and there is a procedural dispute as to whether he should be treated as being in civil or criminal contempt or under what's called recalcitrant witness contempt, which is a sort of third statutory form of contempt used for people who, say, refuse to testify before a grand jury or are called or subpoenaed as a witness and then refuse to testify. If he is considered a recalcitrant witness, there is, I believe, an 18-month limit on how long he is supposed to be held. Obviously, since he's been in for about 2 years, either it's beyond that term or the court has decided not to treat him under that form of contempt.
So we'll move a little bit outside of this story, but
sure.
Let's say it's upheld, the courts, they're able to hold him for as long as they see fit. What are the ramifications for the average person?
I think the really concerning thing about this isn't someone saying, I don't want to comply with this legal order. It's not the typical contempt situation where there's no legal question as to the propriety of the order or the possibility of the order, and someone is sort of willfully refusing. This is someone who First off is making a Fifth Amendment claim saying I should not be required to produce the password, a piece of knowledge, to potentially further my own prosecution. It's in that terminology, it's pretty clearly within the walls of the Fifth Amendment. The other, and I think much more troubling aspect, is he's claimed that he doesn't remember these passwords. And we can go back and forth on whether that's a credible claim, on whether that's to be believed, but it seems that the court has treated his lack of recollection as believable and ordered him to recall the passwords, which I think is, well, I don't know if laughably frightening is a word, but or a term, but that's it almost defies belief.
I mean, it's what's scary then is this idea that if they can do this, let's say, I know so many people who have encrypted drives. For example, I have many encrypted drives. I don't even remember the passwords. I've got a drive from 5-6 years ago with a bunch of artwork, video games, and other political writings or nonsense. Mm-hmm. I wouldn't be able to unlock that. Yeah. And so if they came across this in the course of an investigation, even though it didn't matter, could I find myself in the same situation because I can't recall a password?
And short answer, theoretically, yes. When it comes to these laws, obviously different circuits, different judges, different courts do things differently. But in terms of sort of imagining that potential worst case, this does seem applicable to that kind of scenario. I think journalists, attorneys, investigators, anyone doing work that requires confidential, sensitive storage should be worried about this issue.
One of the interesting things to me about a lot of this is that when we use our phones, when we use computers, when we store, information in an external drive as opposed to storing it within our own heads, it's usually just a convenience. Mm-hmm. There's a lot of instances where I could just decide to try hard to remember a number. Actually, here's a good example. How many phone numbers did we used to remember before cell phones?
Right.
I knew so many, now I know none. Mm-hmm. I think the only phone number I have that I remember by heart is my mom's.
Yeah. Because
my phone stores it all. So we're using external devices as conveniences, but do they have the same protections, right? If a court orders me to recall information, I can plead the Fifth. But can I do that for a phone or a computer?
And this is where we get into kind of the policy and normative arguments here. I think it's generally true that the law is lagging behind in a lot of areas when it comes to technology, and this is a prime example. The fact that I have written something down into a device to store it, the court does not view that as any different or any more private than, say, a filing cabinet, where I've thrown an index card with someone's number or a document I want to save for later for some reason. But the reality, and this is where we get to the couple of court cases that went through the Supreme Court back in 2014, is that these are not devices that are equivalent to a filing cabinet or some sort of single-purpose area within a home or within an office. These are devices that are holding, like you were talking about with your own storage. It's work stuff, it's video games, it's personal writing, it's everything from the most private professional documents to the most private personal documents often end up on the same device with no real specific sort of organization or order to what goes where and when and why. And until there are changes in the law that give a greater right of privacy to those devices and to the contents of those devices, I think it's a very unpredictable area right now. Different courts are going different ways on it, and you've got a lot of different standards in different places kind of bubbling up through the court system. The other concerning thing with this opinion, or this situation, is in some of the filings, the prosecution is claiming that there is no Fifth Amendment issue because they're not asking this person to divulge the password. They're asking him to perform the physical act of typing in the password to unlock the devices, which is also just sort of laughably dystopian absurdity. The idea that there is a tangible legal difference between, hey, give us your password, and hey, type in your password on this device to unlock it. I just don't see how you can even argue that with a straight face.
Yeah, have judges accepted that argument?
In this case, specifically, I'm not sure, and it is the first case I've seen that argument made. Most other cases, even where judges have ordered unlocking or decryption, both parties have been on the same page about the difference between, say, compelling a physical act like a fingerprint unlocking versus compelling a knowledge-based act, such as typing in a password you've memorized. You do get into some sticky situations in the middle ground. For example, if you use a password manager, maybe you remember the password that unlocks the manager, but you probably don't have all of those passwords in your head. And so there are sort of middle ground situations, but this is the first case that I'm aware of where the prosecution's tried to frame it as though typing in a password is different from divulging your memory of it.
So when we hear issues, this is not the only digital privacy and rights issue. I mean, there's way crazier stories out there. But without spending 5 hours talking about it, how do you feel? You're working in law in this area. Are you optimistic that our rights will be protected?
Without new legislation, I'm not. I think the problem with the way that digital rights have been done thus far is that law generally works by way of analogy. So you've got decisions being made about email services, cell phones, encrypted hard drives that are, at their basis, looking backwards to physical phone infrastructure of the 60s and 70s, or physical wiretap practices in the 30s and 40s, where you literally had someone, climbing up the wires to staple some device into the lines. And the problem is that those analogies break down with a lot of digital communication or digital storage, not just because of the way we use technology, but because of the way that technology stores information. It's a fundamentally different landscape, and the number of laws that really address that difference are very few.
So what's going to happen? I mean, we know that technology is developing faster and faster, and the law lags so far behind it. Are we going to solve this problem? Oh, that's not good.
Well, I think you've maybe inadvertently pointed out an important distinction, which is it's a problem if you're a privacy advocate, but the current state of the law, if you are law enforcement or on the prosecution side of things, gives you a great deal of leeway.
If you're an authoritarian, this is great, isn't it?
Precisely, and that's sort of the concerning problem. Is the question: can we solve this problem? Well, maybe 50% of the people involved in this debate view it as a problem, and the other 50% view it as a boon.
See, there's a bias I didn't even realize. I assumed people generally like privacy, but you're right. They're like the prosecution, the law enforcement. They're probably happy as
Right. I mean, you look at the explosion of law enforcement outcry over the going dark problem back in 2015, 2016, when you have statistics that show that a tiny number of devices couldn't be decrypted, were actually unable to be revealed by law enforcement investigations. And it seems like there's a reactionary fear on the side of government and law enforcement when there is a small step forward on the sort of pro-privacy side. So, the question of will we solve this problem, speaking as a privacy advocate, I think if we're going to, it's going to be through legislation and not through the courts. You've had a few states, there's one law that's relatively modern that covers a lot of stored communications and email or like cloud data type situations. It's called the Stored Communications Act. That's under the Electronic Communications Privacy Act. These are sort of 80s, 90s era was when they came about and were being sort of most actively amended. You've seen a couple of states recognize that the language of these laws is now pretty grossly out of date to how we use computers today, even if they were accurate to the BBS and email systems of the 80s. You've had a few, I think mostly on the state level, you've had some reform. I believe California just passed some digital privacy reform in that area that heightened the scrutiny for certain types of discovery. So I think if we are looking for little footholds of progress towards sort of restoring the balance of what privacy should be in this area, it's going to come through legislative efforts, and I think you'll see it coming through. I think you'll see it coming through the states before you see it coming through federally.
Any final thoughts?
It's a concerning case because one of my sort of most core pieces of advice to lawyers, to journalists, to anyone doing sort of sensitive investigative work of any type is encrypt your hard drives, encrypt your phone, use secure messaging whenever you can, and this case seems to stand for the possibility that could put you at risk of indefinite detention if you refuse to,
are unable to.
If you refuse or are unable to decrypt those devices when ordered to by law enforcement. Wow. That's a chilling.
That's why I wanted to talk about it, because I saw that and I was just that's scary.
I think another thing to keep in mind here is that it's quite common for these cases to come through a child pornography investigation or case, and there's an understandable moral panic about that. It's a horrible set of crimes. It's a sort of sickening underbelly of the internet.
Provides like a moral excuse.
It provides a moral excuse, and I think it provides an easy moral argument for those who want fewer privacy rights to make. And it's an easy one to agree with.
They did that with Bitcoin, right?
Yep.
They said, but drug dealers and
Bitcoin,
terrorists are using it.
The Tor browser, any sort of anonymizing or encrypting technology, this argument gets made about. And it's an easy one to make. The problem is that whenever encrypted device questions come up, it's at the investigative stage. It is very easy to lob accusations and say you must open this because we think it contains this damning, sort of morally appropriate piece of evidence.
Yep.
But if it's encrypted, that's all they know. It would be a mistake for us to give up privacy rights out of moral concern based only on allegations.
Yeah. All right, man. Well, thank you for talking.
Yeah, no problem.
Appreciate it.
Good talking to you.
So, for those that are watching, let me know what you think. Comment below. We'll keep the conversation going. Seeing this story online, it really is scary. This idea that you're being compelled essentially to remember something through an indirect act. Type in your password as opposed to tell your password can be scary. And, it'll be interesting to see how this pans out, but let me know what you think. If you like the video, click the like button. You can follow me on Twitter and Instagram @TimCast. And if you want to support the work that I do, make sure you go to timcast.com/donate. Give whatever you'd like or give nothing at all. My videos are always free and available every day at 4 p.m. Thank you all so much for watching, and I'll see you tomorrow.